Hello and welcome to this FedSoc Forum webinar call. Today, July 3rd, 2024, we're delighted to host a Courthouse Subs decision program on Fischer versus United States, which was decided last Friday by the court. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the expert on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I'll keep my introduction of our guest today brief, but if you'd like to know more, you can access his impressive full bio at fedsoc.org. Today, we are fortunate to have with us Ted Cooperstein, who currently serves as an appellate attorney in the boutique law firm of Theodore Cooperstein, PLLC, focusing on criminal and civil appeals in both state and federal court. He is a former career prosecutor with 25 years of service at the U.S. Department of Justice. While there, Mr. Cooperstein served as Assistant United States Attorney for the Southern District of Florida and for the Southern District of Mississippi. Prior to joining the Southern District of Florida, Mr. Cooperstein served as Special Assistant U.S. Attorney, U.S. Attorney's Office for the District of Maryland. He also has previously served as counsel to the Deputy Attorney General at DOJ and as Assistant General Counsel at the FBI Office of the General Counsel. Additionally, he formerly served as a military intelligence officer in the Army Reserves from 1989 to 2011, retiring with the rank of Lieutenant Colonel. During the Trump administration, he was appointed and served as General Counsel of the U.S. Office of Personnel Management. And I will leave it there. One last note, and then I'll hand it over for a set of opening remarks. If you have any questions throughout the program, please do submit those via the question and answer feature, as we'll have an extended portion of today's webinar where we can address those. With that, however, I can hand it off. Mr. Cooperstein, the floor is yours.
Thank you, Kayla. Good afternoon, everyone on the East Coast, and good morning to everybody else. As you no doubt heard, the Fischer versus United States case was an appeal arising out of the events of January 6, 2021 in Washington, D.C. at the Capitol. The focus, however, is a long-standing criminal statute, 18 U.S.C. Section 1512 C, Parts 1 and 2, specifically Part C2. The statute is in the chapter that has to do with administration of justice crimes, or specifically obstruction of justice is the shorthand term for this particular statute. The case arises from the events of January 6, and Mr. Joseph Fischer was one of the many people who came to Washington, D.C. to attend the rallies and protest, and found himself on the grounds of the U.S. Capitol. Mr. Fischer, if I recall correctly, in his instance, had actually come down to the rally, left the District of Columbia, got word through the news of what was happening at the Capitol, went back, arrived at the Capitol grounds after the perimeter was breached and crowds had entered the building, and followed in after them, walked around, and left. He was charged, like many of the defendants, with multiple counts, some misdemeanors such as trespass and entering a prohibited area. But in the particular statute we're talking about, 1512C, is in fact a felony with a maximum penalty of 20 years. The issue arose when Mr. Fischer, along like many other of the January 6 defendants, specifically moved to dismiss the count of his indictment that charged him under this particular statute. The argument was that this particular statute was not designed and did not encompass the particular conduct that he had committed, and could not be stretched so far as to deal with the riot and the altercation and the violent encounters with Capitol Police and other law enforcement that day on the Capitol Hill grounds. This is why there were multiple counts of indictment on most of these defendants. They were often charged with assault on federal officer or other violent crimes. But the consistent theme or thread we see through many hundreds of those who were indicted for the January 6th event was to throw in this 1512C count as a particularly potent felony charge, as I said, has a potential maximum of 20-year sentence. Now, the argument, the motion to dismiss, claimed that basically this statute does not cover the type of conduct that happened. Specifically, 18 U.S.C. 1512 C2 makes criminal the corrupt anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with intent to impair the object's integrity or availability for use in an official proceeding. The specific part next, subpart 2, is what was charged against Mr. Fischer and his co-defendants. Part 2 is otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. So basically, the dispute boils down to, what does that otherwise mean? When the otherwise follows the specific list of enumerated actions in subpart 1, is it limited by that specific list in part 1 when we get to the otherwise in part 2, or is it intended to go more expansively beyond the list in part 1? The defense counsel for Mr. Fischer, as well as the others who made similar motions, argued that, of course, under the statutes of the canons of statutory construction and traditional textual analysis of a statute, the principles should have led to a narrowing of subpart 2, and therefore it would have been limited, as the context of the statute would also suggest, to judicial and evidentiary proceedings, impairment of evidence, or halting investigations, grand jury proceedings, or courtroom trials. Many defendants in the District of Columbia District Court made this or similar motions. All but one district court judge dismissed and denied the motion. The one who took it seriously and evaluated it under the statutory canons of construction was District Judge Carl Nichols. Three defendants in particular had drawn Judge Nichols as their district court judge, one of them being Joseph Fischer, the other two named Lang and Miller. Judge Nichols issued a written opinion analyzing the structure and the text of 1512C, and going through all the statutory canons of construction, he reached a conclusion that indeed this statute really could not cover the facts as alleged in the indictment and the type of conduct that Mr. Fischer was charged with or admitted to, because it was not really a focus of his to impair the availability of evidence or witness testimony or something of that nature. And this in part was because of the nature, the history, and the origin of the statute at 1512C. 1512C was part of the Sarbanes-Oxley statute enacted around 2002, if I recall. It was a direct consequence of what some of us are old enough to remember as the Enron scandal. Enron was a large Texas-based energy company that was caught cooking their books and falsifying much of their accounting records, which led to the collapse of the corporation, as well as at the time, the salient feature was that it really bankrupted the employee pension fund because it had all been invested in stock of the company itself. As a result of that collapse in the big corporate scandal, a white collar incident, there was a task force on corporate fraud in the Department of Justice that had led to charges against the Enron executives, as well as against the major law firm, accounting firm of Arthur Andersen. Arthur Andersen had been responsible for doing audits of the Enron books, and they were blamed for being complicit in the concealment of the cooked books. And part of the investigation, the charges against Arthur Andersen, were that they had destroyed the documents that would have shown the falsity or the cooking of the books and the accounting records. Arthur Andersen, their defense was that this was just a routine document management process, that they destroyed these things after a certain time in all matters. The case actually went all the way to the U.S. Supreme Court with a 9-0 unanimous ruling in favor of Arthur Andersen, but it was too late because Arthur Andersen had already been forced into bankruptcy. But in the course of that prosecution and that white-collar crime scandal of corporate fraud at Enron, it was discovered that the then existing obstruction of justice statute criminalized inducing or making somebody else destroy documents, but did not actually cover somebody who destroyed them himself. So the Congress and the Sarbanes-Oxley legislation, in addition to other provisions, had modified or amended Section 1512 to say that anybody who does these type of destructive and evidentiary impairment, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so, or otherwise as a catch-all provision, with the idea to make sure that nobody would escape liability if they had intentionally been involved in obscuring or trying to hide corporate malfeasance. So that was the case for 20 years. And we know that many federal prosecutors have made good use of these statutes in the course of protecting the integrity of federal criminal prosecutions. When somebody had been caught trying to destroy, withhold, alter, or falsify evidence that was known or could become later essential to a criminal investigation or a federal trial, that was what was covered by the statute. The statute could also cover, say, acts like witness tampering, extortion, intimidation of a witness, seeking to impair the arrival or attendance of a witness at a hearing, and so forth. There was also an organic conspiracy section at 1512K, which made it a crime equally punishable after 20 years to conspire to commit any of those acts in 1512. So that was the status of that statute. And what was unique and novel was, following the January 6th episode, the Department of Justice started to apply this statute to all manner of behavior and conduct from people who had attended or were involved in the January 6 altercations and the riots, or just the trespasses within the Capitol building. The theory being that by being there and adding to the unruliness or the size of the mob, it contributed to the decision and necessity for suspending the joint session of Congress and delaying the proceedings that had been convened for tallying the Electoral College vote that day. So that was considered to be the official proceeding, was made the subject of this statute, and therefore anything people did that could be viewed as contributing to the impairment, delay, or obstruction of that proceeding as it was scheduled to occur January 6th could be charged under the statute in the view of the Department of Justice. This was the theory behind the multiple indictments. At the time of the appeal and the petition for the certiorari in this case, I believe there were about anywhere, depending whether you looked at what was on the clerk's record or what the Department of Justice press releases said, anywhere between 300 and 350 indictments pending. Although I believe the Department of Justice may elsewhere have also claimed to have used this statute in over 1,000 indictments of people related to January 6th. So it was a widespread use of this 20-year maximum felony, in many cases, arguably overused or stretched beyond its intended focus. And that was the argument of the defendants, Lang, Miller, and Fischer. After Judge Nichols had granted their motion to dismiss that count, and you should note and recall, there were multiple other counts against all of these defendants to which they either pled guilty or were found guilty. But this particular appeal and litigation is focused just on the count involving the 20-year maximum felony of 1512C2. Because that was a motion to dismiss, the Department of Justice sought and received from the Solicitor General permission to appeal the dismissal of that count of 1512C2, and it went to the DC Circuit Court of Appeals. Now, the U.S. U.S. Court of Appeals there, in the normal 3-judge panel, reviewed and consolidated these 3 defendants who happened to have drawn Judge Nichols and therefore benefited from his decision. So they were consolidated in one opinion that was heard by and decided by a panel that consisted of Judges Pan, Walker, and Katsas. And the resulting decision of that 3-judge panel in the DC Circuit was wildly diverging 3 opinions. Judge Pan wrote an opinion which was denominated the majority opinion, although it's arguable. She said basically that, well, anything that happened to be otherwise criminal that occurred on or near a proceeding and therefore could be interpreted as affecting that proceeding was fair game. Judge Walker wrote what was denominated a concurrence, and he agreed with the outcome of reversing the dismissal of the count and upholding the application of 1512, but he focused and hung his opinion on the definition of the word corruptly. And he felt in this specific instance of the January 6 events, the definition of the word corruptly, which went to the mens rea or criminal intent, was met by the desire of the protesters to affect or change the outcome of the Electoral College in favor of Donald Trump, so that he felt that that was intending to obtain an unlawful benefit for someone, not for themselves necessarily, but for President Trump. And he felt that was sufficient to sustain the application of 1512C2. The third opinion by Judge Katsas was denominated a dissent, and Judge Katsas pretty much followed the same approach of District Judge Nichols by applying the canons of statutory construction, analyzing the text, the position, the context and history of the text of the statute, deeming it essentially to be narrowly limited to the context of evidentiary impairment or attending the intangible or intangible evidence or witness testimony for an administrative proceeding or judicial proceeding, something of that sort. And he focused on that word otherwise and determined that it should have been construed to be limited by the specific list of items in subpart 1, and therefore was not so expansive as to swallow all of 1 and indeed other parts of 1512 beyond 1512C. There was also the implication in his dissent that this could lead to criminalization of lobbying or other protests that weren't violent, or any other public attendance at the Capitol or hearings by the Congress or congressional committees where people arrive with the express intent of hoping to influence or otherwise affect the outcome of a proceeding. Now, these are presumably permissible attempts, but the broad interpretation, expansion of the statute could be used to criminalize unpopular political lobbying or political protest, absent any altercation or rioting. So those are the three opinions that came from the panel. I should add, and perhaps I should have stated this at the beginning, and I apologize for that. Part of my knowledge comes from being involved in this case, and I filed an amicus brief for 3 other January 6 defendants who were also charged by the government with section 1512C2. At the time we filed, they had not yet been tried, but they clearly would be affected by the outcome and have been affected, will be affected by the outcome of this case. So we filed an amicus brief to add our views to those of Mr. Fischer, both at the cert stage and at the merit stage. And with that in mind, we noted that the 3 divergent opinions, I say they're divergent because they essentially were not reconcilable. No 2 of the 3 judges on the panel, if you read their opinions, truly agreed as to the 2 basic essential elements of any crime, the mens rea or the criminal intent necessary, or the actus reus, what actually what actual conduct is intended to be covered by the statute. So because there was unclear, the initial defendants, both Fischer as well as Lang and Miller, had initially moved for rehearing on bank. I'm sorry, not on bank, but just rehearing by the panel, asking them to clarify their opinion, say, you know, which of these 3 is really the 2 opinions that you're putting through, or should we just view it as nobody agreed, so there's no majority of the 3-judge panel, and therefore the district court opinion should stand. The DC Circuit panel denied that, so we were left taking it to the Supreme Court of the United States. So that was how we got to where we were today, and that we had a case pending before the Supreme Court. There was an argument before the Supreme Court, I believe it was in April, and the sides essentially took those views and focused on what was the proper interpretation of the word otherwise. How expansive could we be? Could this really be applied to this conduct? And also, what were the implications of the unforeseen or unintended consequences if the court should rule either way in not only the remaining January 6 cases, such as my clients, or beyond January 6 to just the normal routine operation of the federal court system across the 94 districts, where this statute has and will continue presumably to be used for judicial administrative crimes. Again, the perjury, the witness tampering, subornation of perjury, or alteration, falsification. For instance, more common uses of this statute that I can attest to are indicting relatives of a murder defendant who happened to find where the key witness was staying in a hotel and imprecating her to withhold or not testify, that type of intimidation. Another type would have been falsifying time and attendance and hourly records of a police force, individual police members who were basically padding their time records to get paid for work they did not do. And when that is actually federally funded, that becomes a federal embezzlement type crime. But it also can be charged under 1512 for falsifying or altering documents that could prove essential to either an audit by the funding government agency or an actual criminal prosecution investigation. So these are the type of evidence impairment proceedings that have been in the past charged under 1512 and necessarily will be, and the outcome of the Supreme Court's decision would have affected that. So we have the decision from the court last week, and it was a 6-3 decision, which is not in itself a surprise in terms of the numbers. It's a sort of standard breakdown of the current court, but was just slightly surprising in that there was a switch of one of the members on each side. The opinion was written by Chief Justice Roberts, who fairly predictably and credibly took the detached scholarly approach that was similar to essentially the opinions of Judge Katsas at the DC Circuit and Judge Nichols in the District Court. Again, of taking the textual statutory canon construction approach, analyzing the setting of the word otherwise, the necessary import of the specific list of prohibited acts in subsection 1, and if and how that would cabin and constrain what is to be considered part of the otherwise in subsection 2. They took the more traditional narrowing approach. I should say what was actually in Judge Katsas's opinion and discussed in some of the briefs, but not in the opinion, was also the, so I'd say it was hovering in the background, shall we say, was the traditional concept of the rule of lenity. The idea is Judge Katsas specified that when you reach a knotty problem of statutory construction and you're dealing with a criminal statute and a significant penalty, if you ever are in doubt and you really can't resolve which way to go, well, the benefit of the doubt should go to the defendant, the rule of lenity. It's easy to send it back to Congress to say, hey, clear this up and specify, did you mean to criminalize this? Conversely, by the separation of powers arguments, it's also not the province of the judges or the judiciary to be writing the law. So to the extent that they might have to fill a gap or extend an otherwise ambiguous portion of the law, it's best for them to leave that undone rather than to stray out of their lane and be doing something that Congress should be doing. A similar argument could be made for the prosecution, and as the executive branch, if they're so adamantly arguing for this expansion of the statute beyond what otherwise is indicated by the text, they're essentially arrogating themselves the role of the Congress and the legislature to create a new statute or extend it beyond its intended application. So these were all arguments that were made at the various levels of the court, even if they did not appear in Chief Justice Roberts' opinion. So Chief Justice Roberts reversed the DC Circuit, said that the otherwise in Section 2 was limited by the specific terms preceding it. Specifically for those of you Latin fans, the canons are those of nocitur associus and eustem generis, which is that you will know the meaning of a word by those it's associated with or surrounded with. And also, if you're listing certain things specifically, then the generic idea should be of the grouping the common denominator of those listings and not to go beyond expanding the realm of what you're affecting. They also considered the potential implications of ruling otherwise, that it would expansively swallow Part 1 to expand Part 2 to include anything not listed in Part 1 of any type, as opposed to those that are specifically analogous to Part 1. And if it were so broad as I would say Judge Pan's opinion, majority opinion, the DC Circuit panel seemed to imply, it really would have swallowed up much of the other specific statutory provisions in Section 1512, or indeed the whole chapter on judicial administrative crimes, process crimes. And Chief Judge Roberts went on to say this was a problem because a broad reading of subsection C2 would criminalize a broad swath of prosaic conduct, including a peaceful protester, and noted that even the Solicitor General at oral argument had conceded that. So although the government's all-encompassing interpretation may be literally permissible, the Chief Justice wrote, it defies the most plausible understanding. So therefore, the case, by the order of the court in the majority opinion, was remanded to the lower courts to evaluate the sufficiency of Mr. Fischer's indictment in light of that opinion. I should add that the final order session this week of the Supreme Court, the other two petitioners, Lang and Miller, their petitions have been held in limbo or in abeyance pending decision of this case, and they were granted, vacated, and remanded for the same consideration of the results in the Fischer opinion. There's an interesting, as I said, the lineup was slightly different from the normally anticipated 6-3 division of the justices, and that was that one of the six was the most recently appointed Justice Jackson, who, perhaps contrary to common expectation, concurred in the majority opinion. I personally attribute, while I welcome her joining the opinion, I attribute it perhaps to her background and the history that she had served as a federal public defender and was therefore able to view this in the longer view, if you will, of how does this affect future defendants outside the January 6th context and the administration of justice. But she made sure in the opening part of her concurring opinion to specify that she in no way was meaning to condone the events of January 6th, of course, or any such thing, but was taking a broader view of just how does a statute that's been around for 20 years and applied successfully, how should it be applied, and how can we make sure that it's continued to be used as Congress intended. So the flip side of Justice Jackson joining the majority of the opinion was that there was a defection from the normal conservative group, and that was Justice Barrett, who wrote the dissent, joined by Sotomayor and Justices Sotomayor and Kagan. She seemed to be a little bit more focused on the factual nature of the January 6th event and not the longer view of what the statute in the abstract was meant to do and how it should operate. She basically took the opposite view of the statutory construction, thought that otherwise should be perfectly understood to encompass just anything and everything that might affect a proceeding, and it would be perfectly fine to apply the statute as the Department of Justice had been doing. And she felt that the court's majority opinion would be creating unnecessary superfluity, and it could not be reconciled. She felt that the Section C1 should not be cabining Section C2. She felt that the majority opinion, therefore, was exaggerating what the outcome might be of the alternate or opposite interpretation that she advocated. So that summarizes for you the opinion as a whole. Now, the immediate implications are, of course, that the indictment for Mr. Fischer, and as I said, for Lang and Miller, they'll both be returned, remanded down first to the DC Circuit for evaluation in light of the opinion, and then ultimately to Judge Nichols in the district court to determine whether or not the indictments on these three defendants, as written and alleged, still suffice to fit within the constrained contours of 1512C2 as specified or illuminated by the majority opinion at the court. Anecdotally, so far, I've been hearing from some of the defense attorneys in the January 6 cases that the Department of Justice and the U.S. Attorney's Office and the D.C. Have not yet thrown in the towel. They're still seeking additional time in the multiple cases that are ongoing to evaluate and see how they might be able to argue, or if needs be, I think they may try to supersede in some cases to try to stretch or recharacterize the factual allegations to fit the new description of how 1512C2 should work in Chief Justice Roberts's opinion. We'll have to see if they're successful at that and how far that goes. The other, maybe obvious, maybe not, but other immediate implication to current events is that many will point out that Section 1512C2, together with the organic conspiracy provision of 1512K, comprise 2 of the 4 or half of the counts in the pending District of Columbia indictment against President Trump. He's alleged in that indictment to have participated in January 6th under 1512C2 in the same manner, and that by 1512K, he's alleged to have conspired with others to help foment or facilitate the violations of 1512C2. So Special Counsel Jack Smith and his team are going to face the same problem of going back to square one, looking at their indictment, seeing if they can argue that they still fit within the new definition of 1512C2, or if they need to supersede or dismiss the count. And we'll have to see what happens with that. Again, it's going to take some time and have to percolate through the courts. And as I said, they're not only looking to see if 1512C2 can still be viable under the new definition description from this opinion, but necessarily 1512K, the conspiracy provision, will be dependent on that, because the conspiracy is just to allege unlawful agreement to commit the violation. So they have to properly charge the substantive violation in order to support and sustain the conspiracy count. So with that, Kayla, I think that pretty much ends my summary. I'm not sure what next would be of interest to the audience, but we're happy to deal with the question and answers now.
Thank you, thank you. Really appreciate that background and the breakdown of the decision, as well as of the other opinions. It's much appreciated. We are moving to our time of Q&A, so to our audience, if you have questions, please do submit those via the Q&A feature. We already have one from an audience member who asks whether it would have been useful to have the majority opinion spend more time why one could not rely on a plain meaning analysis of the otherwise language. From their read, it seems like the opinion skips straight to the canons of interpretation with his judum generis, noctusur, associates, etc.
Well, that's a good question. I think normally a judge or a judicial panel that's looking at any text is going to start with the plain meaning. I mean, we all do that, just looking at words. Well, what does this mean to us on first blush? The problem, I think, is that you can't stop there, because it's evident when there's so much disagreement with dissenting opinions. Remember, of course, I said Judge Nichols was the only district judge to rule this way on the argument. There were 14 other district judges, I'm told, who considered almost identical motions to dismiss 1512C2, and all went the other way. And then, of course, we had the divergent 3 opinions of the DC Circuit panel. So that shows that there really clearly wasn't widespread, broad agreement as to the plain meaning, which is why you then had to go to some other tools in the statutory interpretation box to try to say, well, what can we say this means if nobody agrees on what the plain meaning at first blush is?
Got it. Thank you. So you touched on this a little bit in your summary of the decision and opinions, but I'd love if you could give a little more commentary on whether or not there have been parallel statutes interpreted by the court. I ask particularly because Justice Barrett argues in her dissent that the court reasons from unlike principles.
Well, yes. If you recall, the history of 1512C2 did derive from a white-collar criminal scandal, the Enron corporate fraud crisis. And this chapter and many of these judicial administration statutes frequently are found in the context of white-collar crime, corporate crime. And we've seen in past Supreme Court opinions for the last, 10, 20 years, I'd say, not only the Arthur Anderson opinion, as I mentioned, but also the United States versus Yates opinion was also a Section 1512, I believe, if not a close correlative to 1512. And other statutes in the white collar, I believe, I forget the name, but there was the one about the bridges between New Jersey and New York, where there were some staff members of then Governor Christie's administration who were indicted for manipulating the closure of lanes to affect a political outcome. That was brought as a white collar crime, not necessarily in 1512, but there were also the public service fraud, I forget the exact term, Section 1346 in Title 18, which is adjacent to the wire fraud, bank fraud, and mail fraud type statutes with the typical vehicles for white collar crime prosecutions. And the 1346 was broadly overused to go after politicians who were held to have denied the public of their honest services fraud is the phrase I was looking for. And that's what's in the statute. And so there were a number of cases dealing with that, dismissing or reversing convictions. Another principal one that comes to mind was the opinion of McDonnell, I believe, the former governor of Virginia, who was indicted and convicted for receiving or giving favors in return for certain contributions or favors. And the court had, again, I think it might have been unanimous, but I know it would overwhelmingly rejected that use of the honest services fraud statute. So those were all similar contexts in which the court approached the white collar criminal statute with those same statutes. I'm sorry, I keep confusing canons of statutory construction, but it was the same approach again, that we're not going to give the benefit of the doubt to the government prosecutor. We're going to look very strictly at these texts. We'll apply the rule of lenity, or we'll apply all these canons of construction to make sure that we're being very precise and not sloppy about indicting people or needlessly convicting them when it isn't exactly clear where and how the law applies. So there is a prior history, if you will, and precedent, a thread of cases of applying the same type of approach to similar white collar or administrative crimes.
Got it. Thanks. Next question. Justice Jackson's concurrence heavily focused on the congressional intent behind 1512 C2, and both the majority and the dissent discussed whether or not the situation in question was specifically considered by Congress or intended to be covered by Congress when it passed the same section. To what degree does this decision define, alter, or elucidate how congressional intent may or may not constrain the scope of a statute's efficacy? And does it seem to limit how statutes can be built to account preemptively for what Justice Barrett called known unknowns?
Well, I think this is another instance of the longstanding competing views, if you will, on the value or the use of legislative history. The late Justice Scalia was famous for adamantly rejecting anything beyond or behind the text of the statute, feeling that legislative history, particularly committee prints and reports or statements made on the floor, were notoriously unreliable in his view, to state exactly what the majority of those voting or enacting the statute truly intended, and that the best indication, if not the only indication, was to just look at and analyze the text itself. Justice Scalia's view was a break with the longstanding views of many jurists before him, who happily used legislative history and context and so forth. And you still see it recurring in the approaches and opinions of justices like Justice Jackson or others since then, who are not necessarily in the Scalia camp, but might, as we see here, reach the same conclusion, albeit with different supporting backgrounds. And so to the extent that they are concurring or coordinating, reinforcing. It's essentially reaching the same result by two different paths. I don't know that we've resolved that dispute. It's sort of an existential difference of outlook between how different judges might approach their job. Some will look at it strictly formalistically or textually, and others will try to be more broadly contextual.
Got it. Continuing on that, given how this decision came out, and particularly given the interesting 6-3 split and who ended up on what side, might this change the way that statutes are structured in the future? Does it look like there could be an impact on the way Congress writes laws?
Well, that's tough to say. That stems to the same problems as you just mentioned with just looking at legislative history. Sometimes you just really don't want to know how the sausage is made, or you can't figure it out. How the Congress will approach it, well, these days, and this is my personal opinion, they don't often seem to be in a rush to go correct things. So they're not often passing statutes or amending it. It takes a major crisis like the Enron corporate fraud scandal for them to do what they did in 1512C, and that was 20 years ago. I'm not sure how often since then they've gone back to correct statutes, even though the Supreme Court will prompt them from time to time and say, this is not our job, it's your job, you better go fix this. It happens sometimes, and whether it will affect how they go about it, I'm not quite sure. We hope that they would be attentive to the words they use and those drafting, and hopefully there are legislative attorneys on staff who are helping to apply these statutes, apply these opinions in formulating the statutes. So I guess it's one of those remains to be seen. I can't quite predict.
Got it. Audience question. They ask, does the majority and dissent differ on the standard for statutory construction or only in the application of the same?
That is a good question, because they seem to emphasize the two divergent approaches. The majority does arrive at it by emphasizing the principles and the process of statutory construction. The dissent seems to be more influenced and more concerned about the particular incident and instance of its arising. You don't want to be too cynical, but it may very well be that, you know, the future either side of a particular dispute may be borrowing from either of these approaches, depending on what they see more conducive to making their argument. I think because it's a 6-3 opinion with some participation from one of the justices who's considered to be more the progressive left, we have a greater likelihood of seeing continued principled statutory construction, especially if in the lower courts, as you would expect, they're going to take note of this and take that approach in light of the guidance from the Supreme Court.
Got it. Bundling a couple of questions together here. Does the Justice Department's argument for the broad interpretation that was rejected by the Supreme Court, was that novel for this set of charges for these defendants, or is it something that they've historically held is true under 1512C2? C2.
I'm sorry, Kayla. I blame Zoom, but a little bit of your question was garbled, so I didn't quite hear it all. Can you repeat that for me?
Oh, the question was, is this a novel interpretation by the Justice Department as to whether the broad interpretation of 1512 that was rejected by the court in this case, or have they historically argued for that when they're bringing these sorts of charges?
To my knowledge and experience, it is not. It had not been put forward that way before. As we know from the fact, or we see from the fact that there are multiple counts in all these January 6 indictments, there are already plenty of other statutes governing general violent or disruptive behavior in federal property or certain contexts, or in conflict with federal officers or those assisting federal officers. Those statutes are there. They have already been applied and charged in many of these cases. So that was perhaps one of the other considerations that led to this opinion, is that there's a definite sense of overkill on the part of the Department of Justice to be wielding this 20-year maximum felony as a very large hammer on top of these January 6 defendants, particularly those who you see that there are many who have various charges, trespassing, entering a restricted area, so forth, that would each be misdemeanors, maybe 6 months to 1 year maximum, and then they get the one felony under 1512C that makes it a 20-year felony, and that vastly complicates and exacerbates their sentence calculations, and that of course will go into the calculations of whether or not to plea or go to trial and so forth. I should say that as far as the immediate or medium term consequences going forward for the January 6th defendants, the ones that have multiple felony counts in addition to or aside from 1512C, they may not actually have a practical benefit or effect from this decision. This is mostly going to help those who had only 1512 as their sole felony count and misdemeanors otherwise, because that will drastically reduce their sentence guideline calculation or permissible sentence. And then there are others who may have already served their sentence, but because they're convicted felons, they still have an interest to go back and try to get that reversed so they're no longer branded as felons.
Got it. Continuing on that answer, you've answered some of what are the initial impacts for this case for parties beyond those in the case itself. But are there downstream effects slash industries or areas of law that should be paying attention to not only to the decision in this case, but also to the way it was decided?
Well, yes, of course, as I said, the immediate concern was how would this affect those traditional areas of implementation of 1512, the witness and courtroom and investigation applications of the statute. Those are presumably going to continue as they had been for 20 years until this incident and this appeal. I think the significant limitation is going to be going forward on attempts by the government or the Department of Justice to apply this more broadly going forward in any future instance of anything that might be conceivably near or affecting an official proceeding. And again, I don't think that the opinion truly turned on it, but there is some notion as to how broad or how vague can that definition of an official proceeding be. The argument is that at its narrowest, it was judicial grand jury or trial or something of that sort. Because it wasn't limited to the judicial branch, then we say, well, it could be a congressional hearing, say committee hearings, say there was a mob who went into one of the Senate office buildings and tried to surround a senator in the middle of a justice's confirmation hearing. That might be something that it would apply to. But when there's something on the grounds outside the Capitol building, that's where it starts to be a bit of a stretch. I believe it was Justice Alito at oral argument who asked as a hypothetical, what about people who are continually night after night assaulting the courthouse, clearly alluding to the Portland, Oregon assaults by Antifa in the federal court building that had not been prosecuted. So those are the areas where we may see some more delineation of how far the government may be willing to go to wield these statutes. But again, as we said, there are plenty of other statutes already on the books. So there's quite a mix and match choice of what a prosecutor wants to bring, and depending on what the facts will support.
Got it. A little bit more on the congressional reaction questions. Given the number of cases in which this charge has been brought and the way the decision came out, is there a potential world where we get a congressional attempt to clarify, either to expand or redefine 1512, or a new statute that sort of clarifies what seems to have been ambiguous to some degree?
Oh, sure. I mean, that's always possible, and it's what we'd expect congressmen to do and the committees to do. It's probably a House Judiciary Committee may start taking a look into it, or a Senate Judiciary Committee. And that's what the court essentially is signaling to Congress that they'd like them to do, as well, to the extent there's still some lingering confusion or discontent with the way we've come down and you wish to go otherwise, we'll just go back and amend and change the statute. We know that for 20 years it's been working in the narrower judicial context with witnesses and evidence impairment. The gray area is just how far outside of that context can you expand it if the court has pretty much put their foot down and said, drawn a line, said no further. Well, it's up to Congress to pass a new statute or a different statute or amend this one to allow it to go further.
Got it. Given the apparent direction of DOJ during the current administration, do you expect that this decision could limit or curtail future prosecutions that seek to use a broad interpretation of the law, or will the courts face future similar interpretational disagreements on other statutes?
That's a good question. It's tough to predict what any one administration will do. In the context of January 6th and the District of Columbia District, usually across the country and traditionally, I should say, which is not a good basis these days for predicting, because we do seem to be in a time when a lot of things are not as we might have expected. Traditionally, many of these areas would be left to the discretion of the United States Attorney in his own district. There are certain areas where Department of Justice policy and regulation restrict charging decisions, investigative decisions to particular components of the Department of Justice. This is true, say, in campaign finance, public corruption, certainly in the National Security Division. The prosecutor, under the guidelines as I knew them in DOJ, really can't do anything without first seeking approval and oversight from Washington and Main Justice. We've seen the prosecution of the January 6th cases largely directed from Main Justice, Main DOJ, in close coordination with the U.S. Attorney's Office, which they can do because they're co-located in D.C. In the future, if there are things happening across the country in other districts, it may turn on the nature or the timing of events and exactly what it's about. If it's political, it may well have some close supervision from Washington. If it's just more local centered, local discontent or local dispute, then perhaps the United States Attorney would have more discretion to deal with it. So I basically, that's how I would see it going forward.
Got it. Thanks. Now that we have a decision, and you've touched on this a little bit, so perhaps you can just say, see my earlier comments and move on. What are the questions that remain, if any?
Questions that remain. The key question now is how the parties will, the DOJ will respond as it gets down to the district court, to the trial court. For now, the preliminary indications is that they're scrambling to try to figure out how they can retain 1512 and keep charging people with it, or retain the counts that have been charged, either by recharacterizing or amending the allegations in their indictments, superseding the indictment, or coming up with another theory. They seem reluctant to let it go. So that's one question is, well, how would this go? Another question is how many, excuse me, present or former January 6 defendants might seek to implement or seek relief from this decision. There's the Section 2255 federal habeas provision, the statute that's available for those that have already been convicted and sentenced to seek amendment of their sentence or their convictions. Presumably, there'll be a 1-year statute of limitations running from last Friday when the opinion was handed down for them to seek that type of relief in the trial court before the district judge where they were tried and convicted. Others I know that have not yet been sentenced or not yet been convicted will be filing motions, of course, to get the benefit of the opinion. So that's what we see going forward on those sides. Beyond that, beyond the January 6th setting, it's hard to predict because we don't really know what issues or occurrences will come up. But we can rest assured that the traditional application and judicial administration crimes and evidentiary impairment will certainly go forward. Whether DOJ will be emboldened to keep trying to push a more elastic and expansive application, we'll see.
Got it. Well, I think that's the last of my questions. We're almost to the top of the hour. So are there final comments, questions, thoughts you'd like to leave us with?
Well, from my point of view, it was comforting in a sense to see that the appellate court and the Supreme Court were doing what we expected them to take, a somewhat detached view from a 10,000-foot height which is how they profess to do their job, because they don't always grant certiorari unless they think there's a widespread nationwide implication or effect to be decided in disputes presented to them. So they did that. They took a look at it, not just in the context of the January 6th opinion and its immediate effect, and not just on the political context of the ongoing election campaign and Donald Trump's instances, but rather, how is this to be read? How can we uphold and be consistent with the traditions and the canons of statutory construction? And how do we want to see this statute and others like it interpreted and applied going forward? So I think that was a successful aspect of this opinion.
Got it. Well, Mr. Cooperstein, thank you so much for joining us today. We really appreciate you sharing your time and expertise. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, however, we can wrap a couple minutes early. Thanks all for joining us today. We are adjourned.